If you rent in Florida and face immigration detention, your lease does not automatically end. If you are a landlord with a detained tenant, you cannot simply remove their belongings. Florida's statutes Chapter 83 controls what happens next, not federal immigration status. This video explains how Florida's Residential Landlord-Tenant Act interacts with immigration enforcement under current law. We will cover lease obligations during detention, eviction procedures, security deposit rights, property abandonment rules, and what happens when a tenant cannot appear in court. This is legal information for Florida residents, landlords, and families with members in removal proceedings. Number 1. The legal status of a lease during an immigration hold. When an individual is taken into federal custody, the legal status of their residential lease remains entirely unchanged under federal regulations, specifically 8 CFR 287.7. An immigration detainer serves as a request from Immigration and Customs Enforcement to state or local law enforcement agencies. This detainer requests that the local agency maintain custody of the individual for an additional period not to exceed 48 hours beyond when they would otherwise be released. During this holding period and throughout any subsequent transfer to a long-term federal holding facility, the individual's Florida lease agreement remains fully active and legally binding. Florida Statutes Chapter 83, which governs residential landlord-tenant relationships, contains no provisions that automatically dissolve or pause a lease due to a tenant's incarceration or immigration detention. The contract between the property owner and the tenant stays intact. The tenant retains the legal right of possession to the rental unit, and the landlord retains the legal right to collect rent according to the exact schedule outlined in the contract. In practical terms, this creates an immediate financial friction point. The detained tenant is physically removed from the property and unable to utilize the space. Yet, the financial liability occurs daily. Property management software automatically flags unpaid rent on the day it is due, blind to the reason for the default. If the rent is due on the 1st of the month and the tenant is detained on the 28th of the previous month, the landlord still expects the full payment on the 1st. The law does not grant a grace period or a temporary freeze on financial obligations for individuals facing proceedings under 8 U.S.C. 1227, which outlines the grounds for deportability. Landlords cannot unilaterally cancel the lease merely upon learning that a tenant is in federal custody, as the tenant has not yet breached the contract terms. The strict terms of the lease govern the relationship until a financial default occurs. Because the lease remains active, the inability to pay rent due to detention immediately triggers Florida's statutory eviction mechanisms. Number 2. The 3-day notice requirement for non-payment. When rent goes unpaid, Florida law establishes a rigid, fast-moving timeline for landlords to demand payment or possession of the property. Under Florida Statute Section 83563, a landlord must issue a 3-day written notice to the tenant before filing a formal eviction lawsuit in court. This statute mandates that the tenant must either pay the past due rent in full or vacate the premises within 3 days of receiving the notice. The calculation of these 3 days strictly excludes Saturdays, Sundays, and observed legal holidays. In a standard situation, a landlord or property manager hands this notice directly to the tenant. However, when a tenant is held in an immigration detention center, direct physical delivery becomes impossible. Florida law anticipates situations where a tenant is absent from the dwelling. The statute permits the landlord to leave a copy of the 3-day notice at the residence, typically by taping it to the front door of the rental unit or placing it in the mail slot. The law considers this method, known as posting, to be legally sufficient service of the notice. For a detained tenant, this creates a severe procedural disadvantage. The notice sits on the door of an empty apartment. The tenant held in a facility miles away remains completely unaware that the statutory legal clock has started ticking. The financial consequences accelerate rapidly during this brief window. If the total rent owed is $1,800, the tenant must produce exactly that amount within the 3-day window to halt the process. If a notice is posted on a Friday, the weekend does not count. Day 1 is Monday, Day 2 is Tuesday, and Day 3 is Wednesday. If the rent is not paid by the close of business on Wednesday, the lease is legally breached. The landlord is not required to investigate why the tenant failed to pay, nor are they required to grant leniency if they discover the tenant is in federal custody. Once this 3-day window closes without payment, the landlord gains the legal right to escalate the matter to the county court system. Number 3. The eviction filing process during detention. Following the expiration of the 3-day notice, The landlord initiates formal judicial action under Florida Statutes Section 83.59, which grants the landlord the right of action for possession. The landlord files a complaint for eviction in the local county court, paying the required filing fees. The clerk of court then issues a formal summons which a county sheriff deputy or a licensed private process server must deliver to the tenant. The statutory timeline at this stage remains extremely tight. Florida law provides the tenant with exactly 5 days to respond to the summons. Just like the 3-day notice calculation, this 5-day response period excludes weekends and legal holidays. To legally defend against the eviction action, the tenant must accomplish 2 distinct tasks within this specific 5-day window. They must file a formal written answer with a clerk of the court. They must also deposit the disputed rent money directly into the court registry, which is a secure account managed by the clerk rather than paying the landlord directly. If the tenant is currently detained in a federal holding facility, accomplishing these 2 tasks borders on impossible without immediate outside intervention from a legal representative. The tenant cannot physically travel to the local courthouse to file the written paperwork. Furthermore, they cannot easily arrange for funds to be transferred from their personal bank accounts into the court registry from an immigration detention center due to strict communication and banking access restrictions. If the tenant fails to complete both statutory requirements within the 5 days, Florida law provides the landlord with an immediate procedural advantage. The landlord files a motion for a default judgment. The presiding judge will review the case file, confirm that the 5 days have passed without a written answer or deposited funds, and issue a judgment in favor of the landlord. The county court does not appoint legal representation for the tenant in a civil eviction matter, nor does it delay the proceedings because the tenant is concurrently facing removal proceedings under federal immigration law. A default judgment accelerates the legal process leading directly to the final phase of property recovery by law enforcement. Number 4, the writ of possession and physical property removal. Once the judge signs the final default judgment of eviction, the court authorizes the clerk to issue a writ of possession. This specific legal document is the mechanism that physically transfers control of the property back to the landlord. A county sheriff deputy takes the issued writ and posts it directly on the front door of the rental unit. Under Florida law, the posting of the writ of possession gives the tenant exactly 24 hours to vacate the premises and remove all of their belongings. This 24-hour period is absolute and unrelenting. When the tenant is detained in federal custody, they cannot return to the property to pack their clothing, furniture, financial documents, or family valuables. The 24 hours expire while the apartment remains fully furnished, but completely unoccupied by the tenant. After the 24-hour period ends, the sheriff returns to execute the writ. At this point, the landlord gains the legal authority to change the locks and retake full physical possession of the property. At this exact moment, the law addresses the tenant's personal property left inside the unit. Florida law clearly permits the landlord to remove the tenant's personal belongings and place them at or near the property line, typically the edge of the street, the sidewalk, or the edge of the apartment complex parking lot. The landlord holds no legal obligation to store the property, protect it from weather damage, or secure it from theft. The landlord cannot be held liable for damages to the property once it is placed at the property line under the authority of the executed writ. For an individual in immigration detention, the financial consequences are devastating. They lose their housing and simultaneously face the total loss of their personal possessions, including vital legal documents that may be necessary for their upcoming immigration case. While the formal eviction process is the standard route, landlords must also address situations where a detained tenant's property appears legally abandoned. Number 5, statutory abandonment. Under Section 83.593C, landlords do not always utilize the formal county court eviction process. In highly specific circumstances, a landlord may legally reclaim the property through the principle of statutory abandonment. Florida Statute Section 83.593C dictates the exact conditions under which a residential rental unit is legally presumed to be abandoned by the tenant. Under this statute, abandonment is presumed if the tenant is absent from the premises for a period of time equal to 1/2 the time for periodic rental payments. For a standard month-to-month lease or a yearly lease with monthly payments, this period equates to exactly 15 days. However, the absence alone is not enough. 2 additional critical conditions must be met for the landlord to claim abandonment legally. The rent must not be current, and the tenant must not have notified the landlord in writing of an intended absence. When an individual is abruptly detained by immigration authorities, they are rarely able to secure an opportunity to draft, stamp, and mail a formal written notice of absence to their landlord from the holding facility. If the rent payment date lapses and 15 days pass without payment and without any written notification, the legal presumption of abandonment solidifies under Florida law. Once these strict statutory conditions are met, the landlord is legally permitted to re-enter the property without filing an eviction lawsuit in county court. They can change the locks, officially terminate the lease agreement, and prepare the unit for a new renter. For the detained individual, this means their legal right to their residence evaporates outside of the judicial system. they will receive no court summons and no hearing date. Yet they will completely lose their housing status and possession of all items left inside the residence just the same. Abandonment and eviction procedures become significantly more complicated when the detained individual is not the only person named on the lease agreement. Number 6. Joint tenant and remaining household members. Many residential leases in Florida involve multiple adults signing the same rental agreement. This is highly common in mixed-status households where family members, spouses, or roommates share living expenses to afford the property. When multiple adults sign a lease agreement, they typically enter into a legal state of joint and several liability. This legal concept dictates that every individual signer is 100% responsible for the total financial obligations of the lease. If a household consists of 3 adults paying $2,400 a month in rent, and the primary earner is placed into immigration detention, the remaining 2 tenants are still legally required to pay the full $2,400. Florida law does not require the landlord to accept a partial payment, nor does it allow the remaining tenants to subtract the detained person's share of the rent from the monthly total. If the remaining tenants attempt to pay only $1,600, the landlord holds the full right to refuse the partial payment and issue the 3-day notice for non-payment under Section 83.56. If the full amount is not cured within those 3 days, the landlord will file an eviction action against all individuals named on the lease, regardless of their immigration status or physical presence in the home. The court system will process the eviction against the entire household. The fact that one tenant was removed from the property by federal law enforcement does not shield the remaining occupants from the state's property recovery procedures. An eviction judgment will appear on the public records of all joint tenants, severely damaging their credit scores and hindering their ability to secure future housing. Furthermore, remaining tenants cannot unilaterally remove the detained individual from the lease agreement to qualify for housing assistance or to alter the lease terms. Modifying the signatories of a legally binding contract requires the written consent of all original parties, causing massive procedural delays. During these tense financial situations, landlords might attempt to take matters into their own hands, which Florida law strictly prohibits. Number 7. Prohibited landlord conduct and self-help evictions. When a landlord discovers that a tenant has been detained by immigration authorities, they may incorrectly assume the lease is automatically nullified due to the tenant's absence. Motivated by the financial desire to quickly clear the unit and install a new paying tenant, some landlords might attempt to bypass the county court system entirely. Florida statute section 83.67 explicitly forbids these actions, categorizing them as illegal self-help evictions. The law strictly dictates that a landlord cannot directly or indirectly cause the termination or interruption of any utility service furnished to the tenant. This includes shutting off the water, heat, light, electricity, gas, or elevator service. The landlord is prohibited from turning off these utilities even if the utility bills are in the landlord's name, even if the rent is late, and even if the tenant is completely absent from the property due to federal detention. Furthermore, Section 83.67 prevents the landlord from preventing the tenant from gaining reasonable access to the dwelling unit. The landlord cannot change the locks, remove the outside doors, remove the locks, or remove the tenant's personal property from the dwelling unless the landlord has secured a formal writ of possession from a judge or the tenant has met the strict statutory requirements for abandonment. If a landlord violates this statute, the legal consequences are severe. The tenant holds the right to file a civil lawsuit against the landlord. Even if the tenant is currently in federal custody or facing removal proceedings under 8 U.S.C. 1229A, they or their legal representative can sue the landlord. The statute allows the tenant to recover actual and consequential damages or 3 months' rent, whichever amount is greater. The judge may also order the landlord to pay the tenant's court costs and attorney's fees for the illegal action. If the lease is officially terminated, either through a legal eviction or the end of the term, the fate of the tenant's security deposit must be addressed. Number 8. Handling security deposits after lease termination. The conclusion of a rental agreement, whether through formal eviction, statutory abandonment, or the natural expiration of the lease term, triggers strict protocols regarding the tenant's security deposit. Florida statute section 83.4949 governs the holding, claiming, and returning of these funds, establishing precise timelines for both parties. When the tenant vacates the premises or is removed via a writ, the landlord has 15 days to return the security deposit in full, assuming there is no damage to the property and no unpaid rent on the ledger. However, if the landlord intends to impose a claim on the security deposit, such as to cover unpaid rent resulting from the tenant's detention or to repair property damage, the landlord has exactly 30 days to send a written notice of their intent to impose a claim. The statute requires the landlord to send this notice by certified mail to the tenant's last known mailing address. For a tenant who is unexpectedly detained, their last known address is almost always the rental property itself. The landlord complies with the law by mailing the certified notice to the very apartment the tenant no longer occupies. Florida law gives the tenant exactly 15 days from the receipt of the notice to object in writing to the landlord's financial claim. If the tenant is in federal custody, the certified mail is either returned to the sender or held at the local post office. The tenant never receives the notice and therefore cannot file a written objection within the 15-day window. Consequently, the landlord is legally permitted to deduct the claimed amount and remit any remaining balance. In most cases involving detention and eviction, the tenant completely forfeits their security deposit due to this procedural timeline mismatch. Beyond property laws, recent Florida legislation has introduced additional layers of complication regarding identification and movement for individuals facing immigration scrutiny. Number 9. The impact of Florida SB 1/1718 on transportation and identification. The broader legal environment in Florida significantly impacts how tenants manage housing disputes when facing immigration issues. In 2023, Florida enacted SB 1/1718, a law that altered several state statutes concerning employment identification and transportation. Understanding these changes is critical for households dealing with detention and potential evictions as they directly accelerate financial defaults. Under the amended Florida statutes, Chapter 322, Florida no longer recognizes certain driver licenses issued by other states to undocumented immigrants. If an individual relies on an invalidated out-of-state license to drive to work, they are legally driving without a valid license. A traffic stop from minor infraction can result in a citation or arrest, which subsequently places the individual in the custody of local law enforcement. This local custody creates the exact scenario where federal authorities can issue an IC detainer under 8 CFR 287.7. Furthermore, SB 1/1718 mandates E-Verify for private employers with 25 or more employees, leading to immediate job losses for unauthorized workers, which directly causes the inability to pay rent under Section 83.56. Additionally, amendments to Florida statutes Chapter 775 established criminal penalties for individuals who knowingly and willfully transport undocumented immigrants into the state. While this specific statute focuses on bringing individuals across state lines, the heightened focus on transportation offenses creates a chilling effect on mobility. If a tenant is detained and facing an imminent eviction, their undocumented family members or friends may hesitate to rent a moving truck or drive to the property to retrieve personal belongings. This hesitation to encounter law enforcement while attempting to move furniture or secure a new apartment severely restricts the ability of mixed-status households to mitigate the financial damage of an eviction. The practical result is a higher rate of abandoned property and a slower response to legal summons. These intersecting state laws and federal proceedings mean tenants must consider proactive legal preparations before detention occurs. Number 10. Removal proceedings and managing affairs from detention. When a tenant is formally placed into removal proceedings before an administrative immigration judge under 8 U.S.C. 1229A, the timeline for legal resolution expands significantly. These federal proceedings involve multiple hearings, evidence submission, and scheduling backlogs, meaning cases can take months or even years to conclude. During this extended period of detention, the financial obligations tied to Florida property laws continue to accumulate without interruption. To mitigate the severe financial consequences of an unmanaged lease, accumulating rent debt, and an impending default eviction, individuals often rely on a specific legal instrument known as a durable power of attorney. This legal document grants a designated trusted individual known as the agent the legal authority to act on behalf of the detained person who is the principal. With a properly executed power of attorney, the agent holds the legal right to communicate directly with the property landlord. Without this document, landlords are generally prohibited by state privacy laws and standard lease terms from discussing the renter's financial account with outside family members or friends. The agent can use this legal authority to formally terminate the lease agreement early, negotiate a move-out date, pay outstanding rent from the principal's bank accounts, and legally remove personal belongings before an eviction is filed or a writ of possession is executed by the sheriff. If a tenant is removed from the United States under 8 U.S.C. 1229A without settling their Florida property obligations, the civil eviction judgment remains permanently on their record. Furthermore, the debt owed to the landlord can be sold to collection agencies, which continues to impact their credit history and financial standing within the United States long after their physical departure. Properly understanding these legal mechanisms allows individuals to prepare their households for unexpected legal and financial challenges. To protect your household from these rigid statutory timelines, review your current lease agreement immediately. Identify the specific clauses regarding abandonment, joint liability, and notices. It is vital to maintain documented records of all rent payments and landlord communications. If you or a family member face potential immigration enforcement or housing disputes, consult a licensed Florida attorney who understands the intersection of state property law and federal immigration proceedings. Preparing a durable power of attorney can secure your financial assets if you become incapacitated or detained. Subscribe to the channel for more accurate, fact-based legal updates affecting residents. Stay informed and protect your rights.